So today we're diving into a legal white paper that points to a really startling loophole in the US Constitution. And according to this analysis, it's not some dusty old relic. It's an active mechanism that's affecting lives today. And it all goes back to the very amendment that was supposed to end slavery for good. So here it is, the 13th Amendment. We all know it as the amendment that abolished slavery. But look closely at that one little phrase, except as a punishment for crime. The source material we're digging into today argues that those few words do a lot more than just permit prison labor. It argues they create a constitutional pathway to actual legal enslavement. And that leads to the big question, right? How can one single clause, tucked away in the very amendment that was meant to guarantee freedom, totally flip the script for someone who's been convicted of a crime? Let's break down exactly how the paper argues this works. Okay, first things first. According to this white paper, we have to stop thinking of this clause as just a historical footnote. The argument here is that it's an active constitutional tool, one that completely transforms a person's legal status the second they're convicted. And let's be super clear here. The paper isn't just talking about forced labor in prison. No, the argument is that it's way bigger than that. It's about a total change in a person's legal and constitutional identity, authorizing what the paper calls complete state control over the body. And this legal transformation has a name, at least in this white paper. They call it the status change, a fundamental shift from being a protected citizen to belonging to a whole new and very vulnerable legal category. So here's the absolute crux of the argument. Before conviction, you have an unbreakable, absolute right to be free from slavery. But after conviction, the paper argues, that absolute right is just gone. You now belong to a class of people who can, constitutionally, be subjected to it. And the fallout from this so-called status change is huge and immediate. Yeah, you lose civil rights like voting, but the paper points to something even more critical. You lose your Eighth Amendment protection. Now, what does that mean? It means that slavery, which would obviously be cruel and unusual punishment for any other citizen, becomes constitutionally permissible for a convicted person. This chart really lays it out, just how stark the difference is. One day, you're a protected citizen with full constitutional rights. The next, you're in what the paper calls an enslavable status, where the Constitution's ban on cruel and unusual punishment no longer protects you from the act of being enslaved. And, this status change doesn't just happen in a vacuum. The paper argues it sets off a kind of domino effect, a chain reaction that leads to a whole cascade of other constitutional rights being violated. Now, this might be the most stunning part of the entire legal argument. This massive, life-altering consequence, this status change, it all happens in silence. According to the source, defendants are never told that pleading guilty or being convicted will literally strip them of their absolute constitutional right to be free from slavery. And you can see how this one issue spiderwebs out and touches on other core rights. The paper claims that because defendants aren't warned, their Fifth Amendment right to due process is violated. Because their lawyers don't tell them, their Sixth Amendment right to effective counsel is shot. And because it disproportionately affects certain communities, it poses a direct challenge to the 14th Amendment's promise of equal protection under the law. From there, the paper zooms in on a group it says is especially vulnerable here, and that's young people. For kids who are waived into adult court, the paper argues the harm is just magnified. Think about it. They're placed into this enslavable status during the most formative years of their lives, often with no real grasp of the lifelong consequences they're facing. And the paper drives this point home by referencing a major Supreme Court case, in re Galt, which basically said, hey, kids are entitled to the full protection of due process, just like adults. So the argument goes, failing to tell a young person about this status change isn't just an oversight, it's a massive violation of their established rights. Okay, so that's the problem as laid out by the paper. But it doesn't just stop there. It also highlights a growing movement to actually fix this, a real national push to finally get slavery, in any form, out of the US Constitution once and for all. So is this just talk? Not at all. There's real momentum. Check this out. 8 states have already gone ahead and removed this exact clause from their own state constitutions. So this isn't some theoretical debate. It's a reform movement that is actively winning battles on the ground. And get this. Look at the states on this list. You've got places like Utah, Alabama, and Tennessee right alongside Vermont, Colorado, and Oregon. This isn't a red state or a blue state issue. It shows there's a really broad consensus building that this is a loophole that needs to be closed for good. So what's the path forward? Well, the white paper lays out a pretty clear game plan. It calls on judges to start requiring that defendants are actually told about the status change. It calls on lawmakers to pass abolition measures at the state and federal level. And it calls on advocates to get the word out and build more public awareness around this whole issue. And that really leaves us with a central and pretty profound question that this whole analysis poses. If our system of justice is built on a constitutional foundation that still allows for slavery as a form of punishment, what does that really say about our definition of justice itself?